Well, I guess we can go ahead and get started. I want to be very cognizant of everybody's time. I made a agreement to get you guys out of here in about an hour, so I want to keep you to that. I know everybody's busy, and it's a beautiful day today, so maybe we can all cut out early and enjoy some of this weather before we get all this massive shutdowns tomorrow. Maybe go out.
All right, it's Alice Justice.
Hey, Alice, welcome. Good to see you. If anybody else comes on,
Thank you.
let me know. Well, I'll keep an eye out.
Connie Whitaker.
I got Connie, Patricia, Lucy White. Okay. Just a little commercial reminder. Any of these trainings all these trainings that we're doing, we're actually over the hump today. This is training number 4 of a total of 6. Fortunately or unfortunately, whatever, in your all's eyes, this is the last one that I'm going to be with you. What's going to happen is we got 2 more left. We got one on familial status and one on domestic violence. And Marissa is going to be doing the final 2 because I found out on the last one I have a bunch of vacation time that I need to take before the end of the year. So Marissa is going to do the domestic violence one for me, or the familial status one for me. She was originally scheduled to do the domestic violence, and I was doing familial status. So any of these trainings that we've been doing, we're going to put them on our website. Also be aware that anytime that anybody wants any kind of training, please feel free to give us a call. We provide training free of charge. We'll come out, we'll customize it. Actually, today's presentation is pretty interesting. It's harassment. And usually when we do a general fair housing training, the harassment section is usually maybe about 1 or 2 slides, if that. This is probably the first time I've done a total harassment presentation in a fair housing scenario. A lot of times when people think of harassment, they think of it as an employment issue. And as you will see, this notion of harassment and housing kind of evolved from the fair employment laws, and it is actually an issue that we're seeing a lot in today's times. But any of these trainings that you see, you can direct people to our website, or we can come out. Interesting one about an anecdote one time is we got called down to somewhere down in Kentucky, me and a former investigator, to do some fair housing training. And they wanted us to deal specifically with with general fair housing, but a little emphasis on harassment. So it wasn't a total harassment presentation. And we were sitting there getting ready to do the presentation, and some guys, I believe they were the maintenance people. It was a medium-sized apartment complex, but there were several maintenance people, and we passed out the information. And they looked at our presentation, and one of them made the comment, said, and these parts, harass is 2 words. So we knew, A, we were in the right place to do some training, and B, that if you have some individuals in your organization that have that mindset, it's best to get some kind of training on a regular basis, because it's individuals like that and comments like that can put you in a sticky situation as far as with fair housing laws. But fair housing and the issue of harassment in general is kind of interesting in that you, as an organization, as an apartment complex, can admit that something happened. You can admit that it happened in your apartment, but you can still win your case. Does anybody know how that's possible? And we're going to talk about it a little bit in depth here in a little bit. But does anybody know offhand how you can come to the Human Rights Commission and write on your letter, say, yeah, we admit that it happened, but you can still win? Does anybody know? Want to venture? All right. Well, it all depends about.
You check the proper steps, it didn't happen again.
I'm sorry. Can you repeat that?
If you took the proper steps to ensure it didn't happen again,
Sure.
Such as punishment for the employee or whomever it was.
Yes, you take appropriate steps. What you found out when you found out about it, and what you did when you found out about it, and we'll talk about that and expand on that a little bit later. Has anybody had the fortune or unfortune to have dealt with a harassment type situation in your line of work? And a lot of people, a lot of calls that we take, if you've ever paid attention, a lot of people throw that harassment term around. This person's harassing me. Well, she's harassing me. He's harassing me. What the way we view harassment is a lot different, because a lot of times on the employment side, we'll get somebody that said, "Yeah, my supervisor's harassing me. They're following me around all the time and telling me what to do on a daily basis." It's like, hello, that's what a supervisor is supposed to do. So people love to throw around the term harassment, but what we're going to do today is we're going to learn what a few definitions of the term harassment is, kind of talk about liability, how to recognize harassment, what you need to do as a housing provider, and then I've thrown some slides on the end, in the end there, about how to conduct um, a thorough investigation into these kind of issues. And if there's a little bit time left, we'll open it up. Yeah, along that lines, if anybody has any questions along the way, I'll try to remember to look at the chat as we go. I'm still learning how to finagle this thing, but yeah, any questions, just speak up, please, and we'll go from there. So when we look at the term harassment, let's just look at. I thought it'd be good to look at, number one, at a layman's definition of what harassment is. And it tells us that harassment covers a wide range of behaviors of an offensive nature. It is commonly understood as behavior, apologize for that train, as commonly understood as behavior that demeans, humiliates, or embarrasses a person. And it's characteristically identified by its unlikelihood in terms of social and moral reasonableness. In the legal sense, these are behaviors that appear to be disturbing, upsetting, or threatening. They evolve from discriminatory grounds and have an effect of nullifying a person's rights or impairing a person from benefiting from their rights. When these behaviors become repetitive, it's defined as bullying, and the continuity or repetitiveness and the aspect of the distressing, alarming, or threatening may distinguish it from insult. So what to take away, and as you can see, is it's getting into the legal sense. It involves from a discriminatory place, and it has an effect of nullifying a person's rights. So as we see in employment, you're interfering with somebody's right to work, right to earn a living. And almost in a more personal nature, you're interfering with somebody's rights as where they live. They're not able to enjoy the peace and freedom of their fair housing rights. Everybody has the right to live where they want, free of harassment, free of discrimination. And when you look at harassment, it's behavior that interferes with those persons' rights and prevents them from enjoying, all the things that we enjoy about the places that we live. Now, as I mentioned, when you look at employment law versus fair housing law, both HUD and the courts, let me see if I can move this real quick. This thing's driving me crazy. There we go. Both HUD and the courts have long recognized that Title VIII of the Civil Rights Act of 1968, which is our Fair Housing Act, prohibits harassment in housing and housing-related transactions because of race, color, religion, sex, national origin, disability, and familial status. So Title VII of the Civil Rights Act of 1964, that's what protects discrimination in the realm of employment. So a lot of stuff that we see in housing derived from employment law. That's why we had 4 years of employment law before the Fair Housing Act was passed. So a lot of the legal theories and the legal scenarios that you see that come out of that we see now in fair housing law derived from employment law. And comparatively speaking, in the Federal Register, it makes a comparative statement about employment law versus housing law, saying one's home is a place of privacy, security, and refuge, or it should be. And harassment that occurs in and around one's home can be far more intrusive, violative, and threatening than harassment in the more public environment of one's workplace. So they acknowledge that harassment happens at work, but if harassment happens at the place where you live, It's far more private and far more intrusive and far more of an insult when you're talking about somebody's place that they live than a more public place where it be where your work at your workplace. And interesting enough, as investigators that we've been doing fair housing investigations, I've been doing it since 1997. We didn't really have or deal with a lot of harassment issues probably in the late 90s, early 2000s. And as such, there was not a lot of guidance for investigators if we did have fair housing complaints filed that involved harassment, sexual harassment, or any kind of harassment, any of the protected classes. So although harassment had long been illegal in the area of housing, there was not much guidance and clarity due to the fact that it was more prevalent. Like I said, in employment discrimination, we've been dealing with sexual harassment for a long time. A lot of cases are filed in employment on sexual harassment, not a lot of cases on the housing side. So as you see, HUD didn't have a lot of guidance and legal help for us investigators. And it wasn't until September 14th of 2016 that HUD issued a final rule that set out the legal standards for sexual and other forms of harassment in housing. And again, for it to be considered harassment, excuse me, it has to be, the harassment has to be based on a protected category. So the HUD rule on harassment said it applies to all the protected classes under the Fair Housing Act. And we found out in our very first training that we did, our 7 protected classes are race, color, religion, sex, familial status, national origin, and disability. And it also set out that a single incident of harassment can violate the Fair Housing Act. Now, again, that doesn't mean if somebody says something, let's say somebody says something of a sexual nature, that we have a great case that's going to go to court and the person's going to get a lot of money. What you see in employment law is, yes, one single as soon as the incident becomes unwelcome, that can be a sexual harassment type situation. However, we have to evaluate it on a case by case basis. So if you have a single incident of harassment, yes, it could be a violation, but it also depends on the severity of the incident and what exactly went on. But we have to evaluate those on a case by case basis. And also said the HUD rule also said harassment does not require physical contact. Section 24 of the Code of Federal Registry, 100.600 Section B says harassment can include written, verbal, and other conduct. It can also be something as simple as leering at somebody in a sexual manner. It could be nonverbal gestures. Like I said, emails. It could be, nowadays you got texts on your phone, sending people appropriate pictures, things of that nature. What the HUD rule did do, it didn't define the term harassment in general, but what it did, it broke it down into 2 types of harassment, and this is pretty much identical to what we see in employment law. You got quid pro quo harassment, and you have hostile environment harassment. When you look at the quid pro quo, that's essentially a Latin term, and it means something given in exchange for something else. It's an unwelcome request or demand that makes submission to the request or demand a condition of accessing or maintaining housing because of a protected characteristic. It can occur even if the person agrees to comply with the unwelcome request or demand. The victims have reasons for complying and not complying. If we have a quid pro quo, usually it's somebody has authority over somebody else and says, hey, if you do this for me, I'll do this for you. Even if that person says, if the person says, I'm not going to do it, it's still quid pro quo harassment. Even if they say, yeah, I'll do it, it still falls into the quid pro quo harassment. If the person of authority makes empty threats and they proceed to not follow through with them, they can still constitute quid pro quo harassment. If you don't go out on a date with me, I'm gonna make sure I'm gonna give you a 30-day notice to evict your to leave your apartment. You call that person's bluff and you don't go out with them, and they fail to give you a 30-day eviction notice. They didn't follow through with the threat. It doesn't matter. That still constitutes quid pro quo harassment. Now, we had a local case a couple years ago. We had a male owner of a small apartment building that tended to rent to single females. The single female reported to the Human Rights Commission that when she got behind in her rental payments, the owner proposed that if she had sex with him, her rent would be forgiven and she would not be evicted. So that's a local example of a case that would fall under that quid pro quo harassment. You had somebody of authority. He's the owner of the apartment building. He has control over some of the things of her living situation. When she got behind on the rent, he really had control over things. He could have probably kicked her out for non-payment of rent. In this case, he followed through and said, "Hey, if you have sex with me, I'll forgive your rent and you would not be evicted." So that would fall under quid pro quo harassment. Now, the other one is hostile work environment. That pretty much, I do a lot of employment cases. Hostile environment. That's a situation. It's unwelcome conduct that is sufficiently severe or pervasive. A lot of people say severe and pervasive. It doesn't have to be both. It has to be one or the other. It's sufficiently severe or pervasive such that it interferes with accessing or maintaining housing because of a protected class. The HUD rule establishes what you have to look at. You have to look at the totality of the circumstances. You have to do a test to determine whether or not a hostile environment occurred. And we'll talk about the totality test here in just a second. And of course, this comes from the 24 Code Federal Registry 100.600B21. So when you have hostile environment, you got to look at the totality of the circumstances that, like we mentioned. The factors to consider to determine if a hostile environment on harassment exists. Again, this is not a non-exhaustive list. It can be several factors, but the three main one is the nature of the conduct. What is this person doing? What is the context of the incident? And again, the severity, frequency, the scope, location, and the duration of the conduct. So you have to analyze those kind of situations and put those in perspective to determine whether or not a hostile environment exists. Now, if you're not sure, it's probably safe to say you err on the side of caution and treat it as you would, because you never want to discount one of these situations, because you could find yourself in some sort of illegal quagmire if you just dismiss it off from the very beginning. Physical or psychological harm not required to prove hostile environment harassment, but if evidence of such harm may be relevant in determining if a hostile environment existed and for damages. That's kind of what we look at when we do an investigation at the Human Rights Commission. It's one thing to be harassed on the job or harassed in your housing, but if we're going to take this case to a public hearing, or if we're going to take it to court, one of the things we're interested in is how are you damaged? Did you have any kind of physical or psychological harm? Did you have to go to a psychiatrist? Did you talk to friends and family about it? Did you have to get counseling? Did you go to your preacher and talk about things like that? So that kind of evidence regarding what kind of damages you suffered also is relevant in the totality of the circumstances to determine if hostile environment housing exists. And the standard is that of a reasonable person in the aggrieved person's position. So if a reasonable person would find that behavior offensive, and that is the standard. And that's a standard pretty much that you see across the board in housing and employment. Now, for hostile environment, local case. Now, if you'll notice, a lot of these two examples that I gave you were sex discrimination, sexual harassment, and that's kind of where we see a lot of the complaints that come, whether it be employment or housing. It's usually sex discrimination, sexual harassment. As mentioned, harassment can be other protected categories, but we don't see a lot usually in the other protected categories. Usually it's sex related. And in this case, we had a local hostile environment case. A female tenant made a complaint with the HRC alleging that a male neighbor was making sexual comments to her whenever she would leave or arrive at her apartment. The female alleged that she made a complaint to management, but the behavior continued. So as we had that answer early on, it depends on what you do with the situation and the information once you find out about it. And we'll talk about that a little bit later as far as what you need to do to combat harassment of any kind. Do you have any questions so far? Okay. Other examples of harassment, like I mentioned, we have other protected categories repeatedly. And now these aren't local examples. These are just examples I came up with just, out of the blue. Repeatedly yelling anti-Muslim slurs at a Muslim tenant, taunting and threatening a person with a mental disability, subjecting a person to pervasive racial slurs and or defacing a person's home with racial slurs and images, and derogatory comments about children or having children. Again, familial status is something that's protected in housing and not employment. So obviously, since it's protected class, if you have somebody that's, making fun of somebody for having so many children, we don't like children here, that would constitute familial status harassment. Now we're getting into liability. What is, as a housing provider, what is your liability in a harassment type situation? You have two types. You have direct liability, and that'll be the first one we're going to talk about. So you have direct liability for your own conduct resulting in a discriminatory housing practice. So if you're the manager of the apartment complex and you're the one doing the harassment, then obviously that's a direct liability. Also, your one's failure to take prompt action to correct and end a discriminatory housing practice by that person's employee or agent, where the person knew or should have known of the discriminatory conduct. And this kind of throws people sometimes. Well, you know what the new is. You knew something was going on and you failed to take corrective action. Somebody came to you and said, hey, this is happening to me in my housing. This person is harassing me based on this protected category, and you failed to take any kind of corrective action. But what is this should have known? Does anybody have a scenario where you should have known something? How can I be held liable if I should have known? Does anybody want to weigh in on that?
If you should have known, so as if it's blatantly happening around you and you're choosing to ignore it, even though it's very clearly in front of you.
Very good. Yeah, all the tenants are talking about it. Do you know what's going on over in building E? Those two neighbors are constantly yelling racial slurs at each other, and you're hearing all this stuff, and it's the talk of the property, and you failed to take corrective action. In that situation, you should have known something was going on. I was at another training one time, and we were doing scenarios, and it was kind of like I brought up the scenario of two neighbors were yelling racial comments at each other, and one of the people that was actually in a management position said, it's not my job to get in people's business. I don't need to do anything in that situation. What they do on their own time is their business. It's not my job to find out what's going on. No, your job is to find out what is going on. Your job is to ensure that all your residents have a quiet, enjoyable, safe, quiet place to live, free of harassment, free of discrimination. And if you knew if something was going on, you could be held liable. And obviously, if you knew of something that was going on and you failed to take any kind of corrective action. And one interesting thing is it says prompt action. And in the employment side, they say immediate and appropriate action. Unfortunately, they don't define what immediate is. In this case, they don't define what prompt action is. And if we get somebody that comes into our office and says, "Hey, I want to file a complaint," I went in and made a complaint like that scenario I had a while ago. The male neighbor was making sexual comments at this individual, and let's say she said she came to the office and complained to management, but they failed to do anything. One of our main questions would be, when did you go and when did you complain? So when do you think would be appropriate? What would be immediate and appropriate in that case? What is prompt action? Does anybody want to take a guess? Is it a day? Is it 2 days? Is it a week? Is it 6 months?
Within 72 hours.
Within 72 hours? Okay. I heard somebody else say something but got cut off.
For me,
okay,
if I'm aware of something, it's going to be no later than that next business day for me to handle something of this level.
Sure. Good. And that's good. That's a good rule of thumb to live by. Like I said, we're going to ask that person, when did you go in to complain? And if they said, I went this morning or I went yesterday and make a complaint, we're probably not going to file a complaint at that point. We're going to probably say, let the apartment complex look into it and give them an opportunity to correct the situation. If they fail to correct the situation, let us know, and then we'll file a formal complaint. But we're always going to send them back, and we're going to say, give the place an opportunity to correct the situation. Now, if they come and said, yeah, we went a couple times and it's been 6 months and we still haven't heard anything and they haven't done anything, obviously in our mind, that's not going to be prompt and that's not going to be immediate and appropriate. Yeah, go ahead, Bryn.
Beyond that, and excuse me
No, you're fine.
Interrupting.
I like
beyond questions. When you have like two differing stories, what would be, other than addressing the issue with the person who is doing the harassing or whatever the unlawful practice is to another resident here, other than addressing it, what would be the other burden of our responsibility, particularly if it's something that subsequently happens? And then I'm thinking, what am I going to be able to prove in court?
Sure.
That this person did what they're alleged to have done. What else must I do in circumstances such as that?
Yeah, I'm trying to think if we cover that specifically. Can you put a pin in that question?
Certainly.
And we're going to talk about like what your responsibilities are and kind of the investigation, and ask me that again and we'll get into that there, because I don't want to give up any of my slides that we may talk about. But that's a great question, and I want to make sure we get to that. And the next one is one's failure to okay, we did that one. Taking prompt action cannot include penalizing or otherwise harming the person who alleges this discriminatory housing practice. Example, a landlord cannot evict a tenant who is the subject of ongoing racial harassment as a means of addressing the harassment. So the tenant comes and says, hey, I'm being sexually harassed, or racially harassed, and your solution to the situation is to evict that tenant. That is not a wise idea. As we mentioned in our general fair housing situation, you can't retaliate against people for complaining to our office or bringing forth a complaint of discrimination. So please explore all options except for that one. This comes from 24 Code of Federal Registry 100.7. Now, the third party conduct is this is another way to to become on the hook for direct liability. Power to take prompt action to correct and end a discriminatory housing practice by a third party depends on the extent of the person's control or any other legal responsibility the person may have with respect to the conduct of such third party. So do you have a lot of people that come in and off the property to do things? I remember going to the Lexington Apartment Association's trade show. And the one vendor that always pops in my mind, just because I remember they used to give big coins, is Coin Laundry. I'm just gonna pick on them because that's the first thing I can think of that may. So you have washers and dryers on the property that need to be serviced or changed out or whatever by Coin Laundry. That's a third party that comes onto your property, and you have pretty much control over the fact that they can come onto your property and do things. So if you have a situation where you have an employee of Coin Laundry that's harassing your tenants, you have the power and control and the legal responsibility to protect your residents from any third parties that come in and out of your property at all times. Now, Bryn, you had an example of somebody that might just be living on the property illegally or whatever, a third party like that harassing, you might not have as much liability with that person because you don't know if they're on there. You really don't have a lot of control over them going in and off the property. So, but you would in a situation if you had like a landscaper or any kind of vendor coming onto the property, you would have more direct liability for their conduct as opposed to somebody that might be just wandering on. Certainly, once you found out they're on the property illegally and you could kick them off, that would be legally doing what you need to do. But the reason I brought that up is to show you it's all to the extent of your control of that person being able to be on the property and the way you control them not to do things. So the other one is we have direct liability. Now we have vicarious liability. And vicarious liability is being held liable or responsible for the unlawful actions of a third party. The third party also carries his or her own liability. Like we found out in the very first training that we did, the general fair housing training, housing law has individual liability. Just a reminder, when we do employment law, if we have a supervisor that's discriminating against somebody, when we file a complaint, we file it against the company. That's all we can do. In housing, if we have a maintenance person that's sexually harassing somebody, on that complaint form, we can name the maintenance person, we can name the manager, we can name the owner of the property, the management company, we can name everybody up the full food chain. So with vicarious liability, you can be held liable for that third party. In addition, that third party is also held individually liable for their actions. And again, vicarious liability for a housing discrimination practice by the person's agent or employee, regardless of whether that person knew or should have known of that conduct that resulted in a discriminatory housing practice. So that if that third party commits something, whether it doesn't matter if you knew or you should have known, you're going to be held liable and vicariously liable for that kind of situation. And again, this is all in the HUD. This all comes out of the HUD's rule. That was final rule, they called it, that was published in 2016. And again, I took this from my employment, some of it from my employment presentation. What is not harassment? Like I said, a lot of people like to throw this term around. I'm being harassed. What we say is the normal, courteous, mutually respectful, non-coercive interaction between tenants that are acceptable to and welcome by both parties. And that's a lot of hooey to say. Normal interaction that's welcome and acceptable by both parties. Harassment is not basic neighbor disagreements. A tenant comes to you and says, hey, my neighbor is harassing me. He keeps parking really close to my car. with his car, I told him not to do it. He continues to do that. That's not harassment. That's just a petty neighbor dispute. Behavior or statements that do not involve any of the protected classes. It might show prejudice against a group of people, but it's not prohibited under the law. And a lot of times we see that as with college students. Ever since these college students moved in, this place has turned into party central. Yeah, you could be discriminating against people because they're a member of a class called college students, but there's nothing under the law that prohibits discrimination. You can legally not rent to students because they are students. Likewise, if you make a comment about college students doing nothing but partying and getting drunk and throwing up all over the place, that's not harassment under what we do. And again, repeated requests for tenants to abide by their lease. Hey, you need to pay your rent. Hey, you need to not be loud. Hey, you need to keep your patio clean, or you take out your trash or whatever. That's your job under the law, to tell people to do that. That's not harassment. No matter how much time people complain and cry that this is harassment, it is not harassment under what we do. So what do you need to do as a housing provider? First of all, you got to take every complaint seriously. Oh my gosh, this person again. I can't believe this is the third time they've complained this month. It may be, but just when you let your guard down, this is probably going to be the time that they actually bring something that's worth your time and worth your energy, and probably can get you into trouble if you don't do anything about it. So you need to take every complaint seriously. And I have to remind my investigators to do that as well. Oh, this person again, or whatever. You got to take every complaint. You got to analyze it on a case-by-case basis. Take every complaint seriously. Don't make judgments or assumptions. Oh, there's no way that person got sexually harassed. Have you seen that person? Have you seen, you can't make, as much as they like to creep into our head, you can't let that rule what you do. So don't make judgments or assumptions. And this next one is kind of what brings people to our office. Explain to the tenant that you are taking the accusation very seriously, and that a prompt and thorough investigation will be conducted. When people come, they make a complaint, or not, I'm sorry, when they don't come here, they come to your office, they make a complaint. There's no communication. They take the complaint and they don't hear anything. Behind the scenes, they may be doing a bunch, but they failed to communicate with that tenant. You don't have to say, well, I went into 5B and wrote them up or whatever, but you have to let them know that the situation is being taken care of. You're taking some sort of action, you're doing an investigation, whatever. Just kind of keep them updated on the situation. And that might involve, and might prevent people from coming down to us and complaining. If you, a lot of times people come here because they just, the landlord failed to communicate with them what was going on. And ensure the tenant that he or she will not be retaliated against for coming forward. That's another reason people don't complain, is because, hey, it took me forever to find this apartment that's affordable. It's close to my kid's school. It's close to my work. It's a great neighborhood, great schools. And I'm afraid that if I go and complain, that they're going to throw me out. So you want to encourage people to complain. You want to weed out the bad seeds. You want people to complain so that you can take care of these situations and ensure that other tenants won't face the same harassment as another tenant did. You want to fully cooperate and assist with the investigation of the complaint as needed. Generate adequate documentation regarding the complaint. I'm going to talk about how to investigate here in a second, but I cannot say that enough. Generate the documentation. Because the first thing that we're going to do when we come in, or the first thing that HUD's going to do when they come in, is say, let me see your investigation file. What did you do? What did you do when you found out what the situation is? Well, I did this. Okay, you interviewed people. Let's see the interviews. Sorry, I don't have that. You want to, whoever you talk to, what, and again, with harassment, you might not have a lot of documentation. It's going to come down to a lot of he said, she said kind of situations. And it may come down to talking to other residents, because certainly if this person harassed this person, they might harass somebody else. But whatever route that you do take, you want to make sure you generate the adequate documentation regarding this complaint and keep it in a place that's easily accessible and you can refer to later on. If it is determined that harassment occurred, corrective action should be taken immediately. It's like, I didn't remember to see who answered early on, but you want to take corrective action. And again, immediately is not defined, but within a reasonable amount of time, if you've determined that something did happen, you want to take corrective action. And the corrective measures should be designed to end the harassment and ensure that it does not reoccur. And I think this may be alluding to Bren's question, and we'll explore that here in a little bit. And then make sure the corrective action follows the policy and lease expectations. We talked about a couple presentations ago that you want to make sure you treat everybody across the board. You don't want to, you want to be overzealous in a harassment type situation and then find yourself with another fair housing complaint alleging gender discrimination. So whatever, or any kind of discrimination. So you want to make sure whatever corrective action follows what you've done in the past, so you're not turn right around and then accused of unequal treatment by somebody. You want to make sure that it does not reoccur and that the punishment is adequate, but you got to make sure you're not too overzealous in the situation. And again, we'll get in, we're going to talk about how to handle an investigation. And it starts with the harassment policy. Hopefully everybody has a nice harassment policy that outlines what you won't tolerate, it may go specifically as defining quid pro quo and hostile environment harassment. It may not, it really doesn't have to, but you want to make sure you have a good policy. If you don't have one, you may want to consider getting one. And if anybody needs any kind of help in developing one, we can certainly be a resource to help you with that. So you want to make sure you know, and most importantly, outline what happens to somebody if they violate the harassment policy. Does that mean they're automatically thrown out? Does it mean that they get something in their file, and if it happens again, whatever it is, you need to make sure that when you start the investigation, you start with the policy. And then the second one really goes into pre-investigation. You want to make sure you train all the personnel on the policy. Make sure that as people are coming in, as you add personnel, that they know where to find the policy. If you're like me, when you read that stuff and then something happens at work and you got an employee, like I had somebody come the other day and talked about a specific kind of leave that they wanted, and I had to pull the book off the shelf. So you don't need to be able to recite the policy word for word, but you need to know where to access it, and make sure all your personnel that come on board. And it might be good to revisit the policies on a quarterly basis, on a yearly basis, and kind of go over it with everybody. This is what we kind of do in this kind of situation. You want to report the complaint through the proper chain of command. If you're the top dog, then you're the one that has to deal with it. If it's one of your subordinates, they got to make sure that they know when they get the complaint what they need to do with it, and in turn who they need to report it to. You need to be objective, keep an open mind. Again, like we talked about earlier, you don't want to make assumptions on a situation. You just got to be objective. You got to communicate with all parties, let them know what's going on. That might, again, at the end of the day, save you some kind of headaches with a fair housing complaint. And you want to document. Documentation. I cannot stress that enough. Be specific. You got witnesses. Notarized statements would be great. If you're going to interview people, it may be good to have a witness. Have that witness that witnessed the interview make a witness statement. You want to tie all your investigation up into a nice little bow, should you need it later. Do not retaliate. And again, take immediate and appropriate action. So the investigation, you want to, like I said, you want to remain fair and objective. Do not prejudge the outcome. That's a hard thing for new investigators when when they start with our agency is as soon as somebody comes in for the intake, they've already made up their mind about what's going on. Oh, there's no way that person was discriminated against. Did you hear them? They said they never came to work and then they were fired. Again, you don't want to pre-investigate. We call that you don't want the square peg in the round hole. Just do not prejudge the outcome. Consider the investigation a fact-finding operation. All right. Your goal is to get information from all parties to reach your decision. You want to follow the facts where they lead and weigh the evidence impartially. Conduct all interviews and review all relevant documents before you make your conclusion. So it's kind of like the process that we follow. We get information from all sides. And then once we believe we have enough information to reach a conclusion, that's what we do. We just follow where the evidence takes us. We don't try to do it too early. If things aren't quite making sense, you need to go back and re-interview people. You can do that, but you follow the evidence and you don't steer the evidence in a particular direction. Maintain sensitivity to the issues at hand. We just talked about this yesterday. We had a EEOC training, a regional training yesterday, and they're actually talking about, I forgot what they called it. They called it some sort of cognitive something. I don't know, but essentially what it is people who have been subjected to trauma or any kind of big event. So if you have it's a traditional sense, that's what I'm gonna say. You have a female that's been, let's say, sexually assaulted or sexually harassed. There's going to be some sort of trauma in her head, and you got to be sensitive to those issues. You can't just sit back. It's like, really, why didn't you complain? Why didn't this person complain? Thank goodness, I've never gone through anything like that, and I can't imagine going through anything like that. But you got to put yourself in that person's frame of mind and then remain sensitive to the issues. I mean, why did this person? We had that example of the person complied to the person's request. Why did you do that? Well, we don't know how people are going to react to situations. I have an 18-year-old daughter who's now in the workforce, and I can't imagine anything happening to her on a sexual harassment type situation or anything like that. And so you just got to maintain those kind of sensitivities when you're interviewing witnesses and talking to essentially victims of harassment. Kind of keep the trauma, the notion of their trauma in your mind when you're making judgments and reviewing evidence. And maintain sensitivity to actual or perceived conflicts of interest. A good investigation avoids the appearance of bias and partiality. As people may or may not know, since probably the last 6 years, we left downtown from a city-owned building to the private sector. Our landlord is Winterwood, which a lot of people from Winterwood are on my list of people that are in this training. So if our office ever gets a complaint against Winterwood, although I think we can remain neutral and do a thorough investigation, you don't want to be there to be any actual, even though there's no actual, or perceived. You don't want that perception that you have a conflict of interest. So naturally, if we ever received a complaint against Winterwood, although I think we can be neutral, I would definitely take that complaint and forward on to another agency to investigate, because I don't want there to even be a perception that we were not neutral in an investigation. So likewise, if you're friends with a couple of the residents, and let's say one of the residents is involved in the alleged harassment, and this is somebody you go out to eat, you guys go to happy hour a lot or whatever, if you have that perceived conflict of interest, you want to remove yourself from that situation and maybe get an outside agency to investigate, or somebody else in your office, or even if you have the budget and you have a legal representative, that person could do the investigation for you. So eliminate conflicts of interest. That's a big one. Responsibly record and document critical evidence. Upon learning of a potential policy or legal violation, make an interview plan. All our investigators, all the new ones, basically, new investigators are required to do it. As soon as we file a complaint, they complete an investigation plan. And depending on what the issue is and the basis is, it's a roadmap that lays out where the investigation needs to go to prove or disprove that this particular form of discrimination took place. For example, we have an eviction based on race. This is a legal theory. This is all the evidence that we would need to collect to reach our conclusion, no matter where it went. Likewise, as soon as you learn of a potential policy or legal violation, this says interview plan, make an investigation plan. Include who are all the key witnesses, what kind of relevant documentation might I need in this case. In this case, she said, he got my number and sent me inappropriate text messages. Guess what? Those text messages or photos that he sent are going to be critical evidence. Make sure you secure copies of those. Secure a copy of your specific policy that's in question. Anything else? He wrote something on my car. Do we have a picture? Do we have a picture of what he wrote on our car? He's been arrested for indecent exposure or whatever. Do we have a copy of those police reports? So kind of go through this investigation plan and kind of figure out what your roadmap's going to be to prove or disprove what is going on here. Immediacy is critical in order to collect testimonies. So we talked about 24 hours, 48 hours, 72 hours. Those are critical timelines. And I think everyone that said that they would do it immediately, that's good to do it immediately because everything is still fresh in everybody's mind. The trail does not go cold. The alleged evidence is not going to disappear. The sooner you do it, the easier it is. It's going to be able to collect these kind of evidence. Protect confidentiality if possible. Obviously, if it's a harassment type situation, you might need to divulge who the person is, but as much as you can protect the confidentiality of everybody if possible. And also consider the broader implications of the investigation. How can this investigation affect the company? Will it have business consequences? Do I have a risk for legal exposure, or does the company have a risk for legal exposure? So you want to keep these kind of issues in mind as you're determining where you're going and what kind of investigation you need to do. And finally, a timely and a well-managed investigation may lend credibility to the company's position. So if we come in after you guys have done a very thorough investigation, it's only the way we're going to look at it, it's just going to lend more credibility to what you guys have submitted to us. My big pet peeve is when a company provides a statement to us and says, oh, we did this, we did this, we did this. And the only thing that they provided is the position statement. They haven't provided any evidence to back any of that up. So if you've gone in and you've done a thorough investigation and you have all the documents, you did a plan, you did all the witness statements, all that's going to do is lend credibility to your position. It's going to assist us in the fact development. It may make the investigation go by a whole lot quicker than it normally would. And that in turn mitigates your financial or criminal penalties. And also if it's a situation that unfortunately we've seen, it's very rare, but sometimes situations might find yourself on the news. Unfortunately, if that's the case, your timely and well-managed investigation can also function as a formal public relations response for what has been going on at the apartment complex. So, questions? Anyone? Bryn, did we want to go back to yours? Did any of that answer that?
Yes, we can.
Okay.
Yeah, it did. But it did bring up another question.
Sure.
A lot of times when we have a complaint or something that we have to address, the complaining party will say, well, keep my name confidential, or don't say that I told you. So what would be the best course in trying to maintain, resident confidentiality and then addressing whatever the issue is?
Right. Yeah, I was and again, I hate to keep bringing up employment, but like I said, this is where this stuff came from. But we had a EEOC technical assistance program one time, and the HR person raised their hand and said, "Hey, this person complained, but they told me not to tell anybody. So what do I do in that case? Do I just let it go?" Well, at that point, the knew or should have known. That person comes to you and says, "This has happened." You now know, so you have to do something as it pertains to that. And you in that kind of situation say, well, my job now is, now that you've put me on notice, I have to do an adequate investigation. I will protect your confidentiality as best as possible, but there may be a time where I may have to, reach that a little bit. But now that I've been put on notice, it is my job to investigate this issue. So your liability exposure kind of outweighs the person's need to remain confidential. So does that answer it? It's just communication.
Yeah, it
Again.
does.
Yeah. It's kind of a sticky situation. They don't want, you can investigate, if it's complainant, you can interview other witnesses and say, hey, this person here have, and that's kind of what we do. We have a case against an apartment manager, and what we do is when we interview the witnesses, we could say, your owner, we've got a potential complaint. We don't let them know who filed, but in this kind of situation, it's like, have you witnessed this person saying anything inappropriate to anybody or anything like that? And so you can do things like that without divulging who actually complained, and still get the information you need. But sometimes you may have to say, okay, have you seen this person and this person out and anything happen? What did you see the other day? They're gonna know who that person is. But that's your need to get that information and kind of limit your liability and do what you need to do to protect your company outweighs that person's desire to remain confidential, I believe.
Yeah. All right. Thank you.
Mm-hmm. Any other questions? Okay. Any comments, concerns before we adjourn for the day? Okay, let me.
Is there a way we could get a copy?
Of this presentation?
Is-
I'm sorry,
Yeah, one of our members wasn't able to make it today, but she really wanted to get a copy of today's presentation.
Yes, I will send that out. I will do that right after this.
Thank you.
Anything else? Did anybody come on late? I have a skeleton crew today. We had a couple people. Kingston. Who's Kingston? Somebody's popping up as Kingston.
That's one of my people with Patricia.
Okay, what's her name?
With Kingston and Lucy Group. Her name's Kelsey.
Kelsey?
She's new to our team, so she's been kind of filling in just to watch and be part of it.
Okay, Kelsey Kingston.
Yeah, Kelsey Edwards.
Edwards, sorry. Edwards.
Yes.
All right. Welcome, Kelsey. I think I got everybody else. Now, Lucy White, is that under Diana White?
Yeah.
Okay, you're Diana. Okay. I want to make sure that was the same person. Okay. Yes, I will send this out. And if there's no other questions, we're done. We'll see you in a couple weeks.
Thank you.
I think I'm the only one here from my team. Ray.
Who's
I don't
this?
think any other Winterwood people are here.
Okay. Okay. And if
This
you
is
want to,
Alice.
you can feel
We're
free.
having our ATM virtually.
Okay.